I'm Charles Livingstone. I'm the head of the competition practice at Brody's and a partner in the risk, government and compliance team. I'm joined today by Jamie Dunne, who is a legal director in the same team. And our agenda for the day, um, I will be speaking about how the Digital Markets Competition and Consumers Act 2024, so a real mouthful, which we'll just be calling the DMCCA. I'll be speaking about how that affects which mergers are subject to potential CMA investigation. And then Jamie will cover new powers that the Act gives to the CMA to investigate breaches of competition law and also changes in relation to the penalties and also a little bit on market investigations. So we'll start with the background to the Act. The Act got royal assent earlier this year in May. It does a number of things, but the overall theme is to introduce a new pro-competition digital markets regime and to reform various aspects of competition and consumer protection law in the UK. There are three main parts to the Act. The first is the digital markets regime. So that sets out new rules for designated undertakings that have strategic market status. That will be a series of webinars, never mind a single webinar, so we're not going to do anything on that. We have written a bit on it. We'll include a link to the follow-up email that you get. What we're talking about today is the second topic. So that's competition law, so changes to the Competition Act and the Enterprise Act, introducing new thresholds and jurisdiction tests for mergers and new investigative powers for the CMA. And the third part of the Act is in relation to consumer protection and in particular enhanced protections and transparency requirements for consumers in digital markets. We have been writing on those aspects. There will be webinars on those aspects coming up. But as you'll see on the next slide, the consumer protection stuff is on a slightly longer timetable, which is why that's still to come from our perspective. So in the autumn, CMA guidance will be sent to the UK government for approval, and secondary legislation will be laid before Parliament in order to commence the digital markets regime and the competition law reforms that we're going to be speaking about today. Date still TBC, but advertised as being next month or January. And then the consumer protection regime will commence in April, but some of the most significant changes will be held over to spring of 2026. So in terms of the competition law reform, the Act revises the financial thresholds that give the CMA jurisdiction over mergers. It strengthens the CMA's investigatory and enforcement powers, removing some current restrictions, introducing new duties on businesses and allowing stiffer penalties for failures to comply. And it also changes the scope for challenging CMA decisions in the CAT, and Jamie will come back to those things. And there are also some procedural updates, some which are relevant to me, some to Jamie, which we will get to. So we'll start with changes to UK merger control jurisdiction and procedure. So before we talk about the changes, we'll quickly recap what the current position is. You're looking at Part 3 of the Enterprise Act 2002 for the merger control regime. The CMA has a duty under Section 22 of that Act to refer a transaction, and that means referring it to the CMA's Phase 2 process, where it does a really in-depth, deep dive into the merger, and decides whether it should be permitted or blocked or permitted with conditions. But this duty we're talking about is the CMA's Phase 1 duty. And what they're looking at to begin with is whether they have jurisdiction, and that's the question of whether a transaction creates a relevant merger situation, and that's to do with the thresholds that we'll be talking about today. If they do have jurisdiction, so if there is a relevant merger situation, they don't necessarily have to refer it then. They only refer it if they think that that situation results or may be expected to result in a substantial lessening of competition within any markets in the UK for goods or services. We're not really going to be talking about what it means to have an SLC in a merger scenario today. We are just talking about the changes that are being made to that jurisdiction point. So to the question you might ask yourself, is my deal something over which the CMA has jurisdiction? The CMA does have a couple of exceptions to that duty. So if it thinks the market isn't of sufficient importance, so if you have a very small market where the whole market's worth 10 million or less, then the CMA may think, regardless of the relevant merger situation and the existence of an SLC, that it's not sufficiently important to justify them prioritizing it. And you can also have a situation where you have relevant customer benefits outweighing the SLC. Those are pretty rare. Again, we're not talking about those today. It is still a voluntary regime, which means you don't need to notify even if the CMA has jurisdiction over your deal. But if you proceed with it, then you're doing so at risk, and there's a possibility of the CMA applying scrutiny to that deal retrospectively. And if they are unhappy with what they scrutinise, then there's the risk of them ordering that a completed deal be unwound. So the thresholds at the moment, aka pre-DMCCA, are in Section 23 of the 2002 Act, and there are two separate thresholds, and these are disjunctive. You don't you only need to meet one for the CMA to have jurisdiction. So the first is a turnover test. So if the target company had a UK turnover of 70 million pounds or more, and UK turnover means turnover generated from UK customers, in its last financial year, then the CMA has jurisdiction. And that's all about the size of the target company, and it doesn't really care at all about the size of the acquiring company. At least not the. Remember, all we're talking about here is, does the CMA have jurisdiction? The question of whether the CMA is actually interested in a deal and whether it thinks there might be a substantial lessening of competition, that's a separate question. All we're addressing today is whether you even need to be asking yourself the question, will the CMA care? The second threshold is what we call the share of supply test. You might also call it the market share test, but share of supply is technically the statutory language. So the CMA has jurisdiction if the transaction results in a combined firm that has a share of either the supply of or the purchase of at least a quarter of a particular type of product or service in the UK or in a substantial part thereof. And there are a few different elements that you need to unpack in there. So you have to have both firms or both parties to the merger supplying or producing the same product or service, and then in either the UK as a whole or in a particular part of the UK. So that might be a town in bus mergers, for example. Preston is the famous example for bus merger purposes. Within that geographical area, then at least 25% of the product or service, what we would call the overlap product or service that both parties either supply or purchase, they have 25% or more of that. Now, the words results in means that you need to have what we call an increment. So essentially, there needs to be overlap between the merging businesses. So if you have one business that already has a 50% market share of a particular product, it can go and buy another business that doesn't sell that product or anything that competes with that product. And the CMA won't have jurisdiction over that. But if the target has a 1% market share, then what you have is a 50% plus a 1%. So that's something over which the CMA has jurisdiction. If you had 50% plus 50%, then you would also have something that the CMA would care very much about. But again, just talking about jurisdiction here. So the CMA does have significant discretion to identify what the market is for the purposes of that share of supply test. So it has quite a lot of discretion over whether it would approach it on a UK-wide basis or would find a smaller local market where the parties' shares are potentially much higher than they are on a national basis. They also have a lot of discretion on what products or services they include or exclude in the denominator for the purposes of calculating whether you have 25%. So you might have the parties produce one particular type of widget, even if that widget is interchangeable with another widget that's of a slightly different type produced by other firms. The CMA could say, well, we're going to exclude widget B from our calculations and only look at widget A. And on that basis, your share of supply isn't 10%, it's 40%. So we therefore have jurisdiction. So there's a lot of leeway for the CMA in relation to that test. However, there is still the requirement to identify an overlap between the parties. And this is where the CMA has had some challenges to which it has reacted, let's say, creatively in some cases. A well-known one relating to Meta, Facebook, where they have decided that a target is active in the UK, even though it doesn't generate any sales in the UK, but because it has a presence in the UK. Sorry, can we go back a slide, please? So that's been a challenge under the current merger control regime, and the CMA's therefore had to come up with innovative ways to give itself jurisdiction over what are called killer acquisitions. So in tech, the theory behind the concept of a killer acquisition is that you have a big player like Meta in the case that I mentioned that has a very established market presence. There's a sort of innovative new piece of software that's being developed and about to come onto the market. And if it comes onto the market, it could significantly increase the competition that Meta faces. I'm not saying that's the case in actuality for Meta, but that's the theory. And therefore, Meta, rather than letting it develop and become a competitor, Meta buys it. Now, Meta might buy it and incorporate it into its own offering and make its own offering much better, but the principle is the same. That potential competitor is no longer going to become an actual competitor, and that's why this concept is called killer acquisitions. So moving on now to the new thresholds. We'll come back to the killer acquisitions on the next slide, so hold your thoughts on that. The first couple of changes are relevant to all mergers, so your meat and potatoes mergers as well as the tech ones that get all the headlines. So the turnover threshold has been modified, and the target turnover threshold for CMA jurisdiction has been raised from £70 million to £100 million. The 70 million has been retained for permitting government intervention in media mergers, so newspapers and things like that. I'm not sure I've ever understood entirely why that should be. I think possibly the previous government didn't want to be accused of doing Rupert Murdoch any favors or something like that. So the 70 million threshold is still there for the Secretary of State's power to issue notices intervening in media mergers that don't otherwise meet the thresholds. That increase to £100 million is not inflationary. It's kind of been described as inflationary, but if it had actually kept pace with inflation from when it was first set in 2002, that 70 million threshold would now be 126 million. So it's below inflation, but it is at least something, and at last, and it should reduce the number of smaller mergers that are. May or may not reduce the number of smaller mergers that are subject to review by the CMA, because the number that the CMA actually gets interested in that sort of 70 to 100 million window is probably not terribly high. But it does mean that smaller mergers or mergers that are in that window will have to care less about the CMA. So you won't need to ask yourself the question, will the CMA care about it? Unless you meet the share of supply test, of course. But then when we get into the share of supply test, and we're talking about the de minimis threshold that's been added by the Act, this is about small mergers. So this means that so at the moment, as I said in the previous slides, there's basically no turnover threshold that goes hand in hand with the share of supply threshold. So you can have two parties to a merger that both have a very high share of supply in a small local jurisdiction, even though neither of them really has much turnover to speak of. Technically, CMA still has jurisdiction over that. Um, the new de minimis threshold says that the CMA basically removes jurisdiction from the CMA even where the share of supply threshold is met if neither party has a UK turnover that exceeds £10 million. So again, question mark over how many mergers the CMA would actually have been interested in, or that would actually have been notified to the CMA or called in by the CMA, that are in that category where nobody has £10 million plus. But where it's very helpful is that it provides greater certainty for mergers and acquisitions that involve smaller parties, local markets, things like that. So my corporate colleagues will be happy that they no longer have to ask us questions about share of supply in even relatively small cases. We can all keep our powder dry for parties that have a bit more going on. And it's probably, I think certainty is the real driver of that change, rather than a fear that the CMA was getting involved in too many small cases. It's really about giving comfort that the CMA will not and cannot get involved in these anymore. We then get to our new killer acquisition acquirer focus threshold, which is set out on the next slide. This says that in addition to our increased turnover threshold and our share of supply test, the CMA will also have jurisdiction, and this one's slightly more complicated, but it will also have jurisdiction if one party to the transaction already has a share of supply or purchase of at least 33% or more of a particular product or service in the UK, or again, a substantial part thereof. So what's substantial? Preston might be substantial enough. So local markets or national markets, you need a 33% market share. Now, this could be the buyer or it could be the target. You also need that party, so the same party that has the 33% market share, to have a UK turnover of more than £350 million. So maybe Preston isn't going to cut it in terms of generating that much revenue. So what you're talking about here is either a buyer or a target that is big in terms of turnover and a very significant player in relation to a particular product or service. That's your starting point. Then you need at least one other party. So if your first two bullets are met by your target, you need the buyer to be formed in the UK or to carry on activities in the UK or to supply goods or services in the UK. Alternatively, if your first two bullets are the buyer, then you need your target to have some UK presence. And that's really so that you don't get entirely foreign buyers or targets getting swept up in this jurisdiction. So both sides need to have at least some UK presence, but one of them needs to have a very big UK presence. Now, the main thing to take from this, as distinct from the other tests, is that you don't need any overlap. So because you no longer need an overlap, the CMA can now examine any merger that involves a party with a large turnover and a high UK market share, as long as the other party has a connection, and that could be as limited a connection as to one UK customer. So you might have Microsoft buying a small niche startup in Dundee. That would qualify under that threshold, and the CMA would be able to look at it. And the point of it is to give the CMA greater scope to intervene in these sorts of deals in order to protect future competition and market disruptors and to help deal with that killer acquisition concern. So the last point on mergers before I hand over to Jamie, there is the Act introduces a new fast track mechanism for mergers. There's kind of a fast track that exists already, but it's a little bit complicated because at the moment you can't put a merger into the more detailed phase 2 process until the CMA has concluded at phase 1 that it thinks there is or could be a substantial lessening of competition. So the CMA does need to have gone through that process in order to move something on to phase 2. Now, there have been mergers like Sainsbury's Asda, for example, where everybody knew it was going to phase 2. The parties would have been perfectly happy just to go straight to phase 2, because phase 2 is basically a de novo consideration of the merger. It doesn't really rely on anything that happened at phase one. So just getting straight into phase two is thought to be an advantage in those sorts of deals. So the parties have to request it. If it's requested, the CMA has to decide within its initial 40 working day phase one period whether to fast track it. Um, but it does mean, while they still have that whole period available to them, it does mean that they don't, within that period, have to find a likelihood of an SLC. So potentially problematic mergers, or even just mergers like Sainsbury's Asda, which was blocked, but that was probably always going to go to phase two, if only because it was so incredibly complicated, and it had so much going on in it. So problematic mergers or just very complex mergers, uh, get them into that phase two process quicker, and then hopefully they come out of it quicker in terms of their resolution. But this mechanism isn't available for mergers in the energy sector. Just a footnote to that. So that's our quick run through on changes to the merger control process. I will now hand over to Jamie to talk first about market studies and investigations.
Thanks, Charles. Yep, we start our next segment of this with changes to market studies and market investigations, and the changes to the CME's powers in relation to those. So just as a very quick recap, what this is about is the CME's current powers under the Enterprise Act to look at markets where the CMA thinks that the market just isn't really functioning very well. So, for example, a very recent market study has been into the house building market within the UK, and another one into vet services, so animal healthcare services. The idea essentially being that where the CMA thinks that there's a market that has issues with it, it wants to look at those issues in a bit more detail and think about how to go about resolving them and what might be required to do that. So, in terms of the changes that the new Act brings about to the CMA's powers in relation to market studies and market investigations, first of all, the CMA is going to get a new power to revisit a decision where it previously decided not to proceed with an in-depth market investigation after a market study. So currently, the CMA will undertake a market study. That's almost a sort of the market study equivalent of phase one in a merger scenario. And if they think that there's a problem, they'll move it on to a phase two, if you like, market investigation. But if they decide not to, then they're currently they can't really just go back and move on to if they change their mind or if new information comes to light, they have to go back and revisit the whole process of the initial market study. What this does is it allows them, having concluded at the end of a market study that they don't want to proceed with a market investigation, they can then go back and change their mind on that and effectively reopen the existing process at the place they stopped it and move it forward to a market investigation or that phase two element of it. And the purpose of this is to enable the CMA to effectively respond to new market developments without having to go back and study the market again from scratch. So that's particularly important in fast evolving sectors, things like technology, digital markets, where the market can just move very quickly, and that may change the reason that the CMA has concluded originally not to proceed to that market investigation step. This gives them the power to go back and say, all right, actually, we are going to do that now. We've got all that information we got at that market study phase, and we're going to move on to that market investigation phase. Now, the limit to that is that it's not designed under the new rules to be used very quickly. It's not designed to just be a sudden change of heart by the CMA. And the way that the Act achieves that is by saying that the CMA can't generally revisit its conclusion at the end of a market study, unless within 2 years of that conclusion. So if the CMA says we're not going to proceed away from the market study to a market investigation, we're going to stop there, we don't think there's enough of a problem, then effectively they can't change their mind for 2 years under this provision. Unless, and here's the key point, unless there's a material change in circumstances since the study. So it can't just be a change of heart within 2 years. It has to be something that's based on changes in the way that the market works, material changes in how the market functions. But if that is there, then they can go back within the 2 year period. If we move on then to the next point, which is what the CME does at the end of a market investigation. So currently under the Enterprise Act, at the end of that market investigation phase, once the CMA has done its study, it's done its investigation, it's concluded that this market has a problem, it can then put in place remedies. It can put in place an order, it can make recommendations, it can do other things, but it can also put in place an order to participants in that market saying you are going to have to behave differently. And those orders are binding on those people that are covered by them. So some examples of that over the last little while, the groceries market investigation controlled land order, which regulates the way that large supermarkets compete in terms of where they build shops, where they buy land for shops, where they get leases, etc. Um, the retail banking market investigation order about mandating open banking. So this is the order that effectively compels your bank to let you bring over all your other accounts and credit cards and so on to your main app that you use for banking and allows you to switch between banks more easily. And the funerals market investigation order, which was really all about regulating the way that funeral services are sold before people die and saving schemes associated with that before people die. So regulating those selling activities. So that's the type of thing that's generally done at the end of a market investigation to regulate the way the market works going forward. And the CMA can impose all that type of obligation about selling practices, transparency, pricing, switching, and so on. What this Act now does, what the DMCCA does, is it allows the CMA to trial remedies before it sets final ones in the terms of an order. So the authority can enter into a trial remedy period where they give they give a try to, for example, changing the way that they regulate the way things are sold, or require a bit more transparency before they maybe either conclude, well, you know what, that's worked, we're going to make that permanent, or that doesn't look like it's working, maybe we're going to have to do something harsher. What this may therefore result in is the CMA experimenting with maybe more light touch remedies at the conclusion of market investigations, because it knows that if they don't work during the trial period, they can revisit them rather than going for the full harsh version right away, just in case something that's lighter touch wouldn't have worked. So that's the trial period for remedies there then. Moving on to some new CMA powers when investigating breaches of competition law. So this is about changing the Competition Act 1998. If we move on to the next slide, and some significant changes to the CMA's investigatory powers, all about making it easier for the CMA to investigate breaches of competition law. So I'll cover these in a bit more detail, but it's about accessing documents, including electronic information, enhanced warrant powers, and new procedures for international cooperation. So first of all, on the subject of power to access and seize documents, on the next slide. The CME now has the power to enter business premises under a warrant, not only as it did before, where it has reasonable grounds to suspect documents or information that relate to a CMA investigation are on the premises, but also now where it has reasonable grounds to suspect such documents or information are accessible from the premises, regardless of where they might be located in the world. The point here is previously the CMA had to have reasonable belief that something relevant was actually sitting on the premises. But that doesn't really work so well in an age of paperless offices. And while the CMA was able to try and sort of uh, massage its way around some of these rules the way they were previously written, the point about these updates is about making it very clear and beyond doubt that the CMA has the authority to downraid a building, regardless of whether it's completely paperless and everything is only reachable through remote means. So the CMA also, in connection with that, has new specific powers to operate equipment on the premises itself in order to access that information. It doesn't have to rely on the cooperation of people on the premises and threatening them with punishment. It can just take over, chuck you out your chair, and go on the computer itself. Require assistance in terms of providing passwords or administrative access. And also, the CME now has more powers to take away information which doesn't relate to the investigation they were there to do to begin with, which ties in a little bit to some of the points we'll come on to in the following slides. So the CMA also has additional powers in relation to domestic premises. The CMA has always had the power to raid domestic premises that were relevant to investigation using a warrant. But what these new changes do is give the CMA more powers to what's called seize and sift. So effectively take away anything it finds on domestic premises to go over it later. Could always do that on business premises. Remember, all this is under a warrant. But it used to be that, for example, the CMA couldn't take away just bags filled with filled with mobile phones or laptops or documents from domestic premises to go through them at its offices. So, I mean, the really key point here is anything the CMA finds on domestic premises in the course of an investigation under a warrant, even if it is the managing director of a business's daughter's phone, if the CMA thinks that it may have to go through that later at its leisure in order to check whether it contains anything relevant to its investigation, it will now have powers to do that. And again, this is about updating the CMA's Dawn raid powers to cope with an age of hybrid and remote working effectively. Um, there are expanded powers to require witness attendance. Primarily, this is really more about making it easier for witnesses than anything else. So the CMA has enhanced powers to require individuals to attend interviews or provide testimony remotely, rather than heading off down to London from wherever you may be to do it in person or having them come to you. The CMA's ability to compel witnesses to provide testimony is expanded beyond those who are directly connected to an investigation. So any director or employee of a company, regardless of whether the CMA thinks they may be connected, can now be compelled to provide an interview, to provide evidence. And any individual who has or may have information relevant to the investigation can now be required to do so beyond just those people. And that might be anybody that's, for example, been present at a meeting, regardless of whether they worked for the company at all. International cooperation and assistance. Not spend too much time on this, but the CMA has additional powers now to cooperate with overseas regulators. This is about providing assistance to regulators overseas and is really just about tightening up and making it clearer that the CMA can take information that it holds and provide that to a regulator abroad that has corresponding functions to those of the CMA. So really any competition authority anywhere else in the world, if it is either under an international cooperation arrangement, so at some form of treaty, or where the Secretary of State, that is to say the UK government, specifically authorises cooperation with that country. The limits are the CMA may not do so if the matter is not sufficiently serious, or if the requesting authority wouldn't reciprocate. Think about unfriendly regimes or maybe friendly regimes that don't tend to work against their own citizens. The US may or may not fall into that category, for example, where assistance would be contrary to the public interest, or where the matter is a criminal one and no international cooperation arrangement exists, which is to say, without a treaty, the Secretary of State effectively cannot authorize the CMA to go giving information to foreign regulators where something is a criminal offence in that other country rather than just a civil penalty problem. And then finally, some DMCCA changes to penalties. There are enhanced penalties for businesses and individuals who either fail to comply with CMA orders or remedies. So think about the type of thing I was talking about a moment ago in terms of the end of an order at the end of a market investigation. Previously, the CMA would have to take you to court to say you've not followed what we told you to and ask the court to impose a penalty. Now the CMA can impose a penalty itself. There are also expanded penalties for obstructing a CMA investigation, for example, failing to provide information on time when the CMA, for example, sends you a questionnaire about a merger, or providing misleading information in such a response, or refusing to provide access or information in a Dawn raid. Previously, administrative or procedural penalties were were limited to £30,000 or £15,000 per day for an ongoing breach. Now it can be 1% of the business's turnover for a single penalty, or 5% of daily turnover per day for ongoing breaches. So that is really just designed to increase those penalties and make cooperation more attractive, if you like. There are also now fixed and daily penalties, not only for the business involved, but also for individuals. So if you are a director within a business or any individual working within a business, you may also face a personal penalty now, and that can include director disqualification for directors associated not just with breaches substantively of competition law, being the member of a cartel, if you like, but also concerning your failure to cooperate in certain investigations and so on. So a lot more scope for punishment for failure to comply.
Great. Thank you, Jamie. So we've got a bit of time for questions. We've got a few to answer, but if you have a question that you've not put in, then please do so now, and we should be able to get to it. Jamie, there are a couple there about challenging CMA decisions and preserving information. If you want to have a think about those while I pick up a couple of questions on the merger regime. So one question is, are any of the new changes to mergers mandatory rather than voluntary? So nothing, nothing that's been changed changes the voluntary nature of the UK merger control regime. And just to recap, what we mean by voluntary is that unlike most other jurisdictions, you don't have to notify something even though it's within the scope of the competition authority's jurisdiction. In most jurisdictions, there is a mandatory notification requirement. Usually that's done by reference to just the party's turnover. So in the EU, for example, that's relatively straightforward because it's just a maths thing, so relatively easy to manage. There are countries that have a combination of mandatory notification and a share of supply test, which is horrible. But yeah, in the UK, it remains the case that everything's voluntary. There was when there was discussion previously about potential changes to the jurisdiction thresholds, one of the options that was often floated was having a sort of an upper band of target turnover, 200 million, 250 million, something like that, above which you would have an obligation to notify. In that scenario and in other jurisdictions, when you have the obligation to notify, it's almost always accompanied by an obligation not to complete until you have approval. So there was often talk about having a higher threshold at which you just have mandatory notification, so you wouldn't need, if only to avoid the stressful process of trying to anticipate whether an SLC might exist if the CMA looked at it. But no, it remains the case that all the thresholds are for the purposes of the voluntary regime. And the new killer acquisition threshold, if we can call it that, is intended to give the CMA more scope to intervene in those mergers. Now, obviously, if the CMA has scope to intervene in your merger, then the question you should always be asking yourself is, if I complete this and the CMA finds out about it, will the CMA intervene? Because if it will, you really don't want that to happen after you've completed, if only because you have to hold separate orders, which are absolutely horrible. Yeah, our advice to buyers where there's a risk of the CMA being interested and having jurisdiction tends to be, well, either notify it to the CMA or at least brief them on it and get a no further questions response to at least get a bit of comfort about that. Related question, does the new de minimis rule prohibit the CMA from calling in a merger or sending out a questionnaire if the parties are below that size? So it does prohibit the CMA from calling in a merger because if there's no party involved in the deal that has UK turnover that's above that 10 million threshold, then you do not have a relevant merger situation, and therefore the CMA can't do anything with that merger. In terms of sending out a questionnaire, the CMA doesn't send out questionnaires for deals that it knows it doesn't have jurisdiction over. So if the CMA knows that none of the parties have 10 million turnover, then it won't send a questionnaire. But the questionnaire may be the means by which the CMA discovers that the parties have all have turnover below that threshold. Um, so if you do have a deal where that's the case, and you get a CMA questionnaire that asks for party turnover and party share supply and parties' activities and that sort of thing, you may just be able to go back once these changes are in force and say, yeah, never mind all those other questions. We're all below 10 million here. Thank you very much. So we assume that resolves all your questions. So might still get questionnaires, but won't get call-ins in that scenario. And actually, CMA's been very busy with questionnaires recently. We've had a little flurry. They do tend to be like buses. I think the CMA, some people have maybe had a little bit more time on their hands the last few weeks. Um, so, Jamie, what are the new limits on challenging CMA decisions? Which I think is what we mentioned on an earlier slide, but then didn't
We
come back
we
to.
did a little briefly. The so it's quite complicated, but at a high level, it used to be that effectively you could challenge pretty much any decision of the CMA, what's called on the merits. So essentially saying the CMA got it wrong, and you could go to the Competition Appeal Tribunal and say the CMA got it wrong and ask the Competition Appeal Tribunal to decide on whether they were wrong or right. There are now certain decisions that the CMA can make. For example, around well, a lot of the stuff around the new digital markets regime, but also in terms of what we've been talking about in terms of the type of order that the CMA can set at the end of a market study or investigation, or certain requirements in the course of competition investigations and so on. That sort of imposition of an obligation type decision, those decisions are most of them now going to be subject to judicial review standards of challenge instead of merit. So it wouldn't be enough to say to the Competition Appeal Tribunal the CMA got that wrong. You would have to say that the CMA got that so irrationally wrong that no other decision maker would ever have concluded the same thing, or that it failed to take account of all relevant considerations, or that it took irrelevant things into account. So it becomes effectively, for a lot of things, not penalties, but for a lot of decisions substantively, it becomes much harder to challenge what the CMA has done.
Yeah, and that's been quite controversial. There's been that's always been the threshold for merger cases, but in a merger decision, you're not being, you're not being found to essentially have
Yeah,
broken the law and fined. You just don't get to have your merger. So that lower threshold was, or I suppose a higher threshold, that higher bar in
yeah.
merger circumstances is was more traditional. But in relation to investigations and things like that, I suspect in due course there will be some ECHR challenges to whether that's an appropriate level of safeguard against regulatory overreach. Um, and there's then a question about new duty to preserve information. You okay to talk
Yeah,
about
also,
that?
also a bit of a controversial one actually when this was being put through. There's a new obligation effectively to preserve anything that you reasonably um, think or reasonably ought to think would be relevant to an existing or potential CMA investigation into your business. So obviously there's a sort of there's the things that this is particularly aimed at. Don't go shredding documents because you think that they make you look guilty and you think the CMA might find them one day. But the obligation kind of goes quite far beyond that in terms of I, thinking about what might be of interest to the CMA. And of course, if you don't know anything about a potential breach, you might not have any cause to believe that some the information will be relevant to the CMA investigation. But somebody in your business has presumably been involved in the initial breach, if there has been one, and therefore somebody in your business knows that this information is potentially relevant. So the whole thing is a little bit fraught. But in essence is an obligation to maintain and hold any evidence as to your own guilt in a potential competition law breach, really indefinitely, regardless of, for example, whether you are applying to the CMA for leniency in terms of a competition investigation.
Okay. All right. Well, that's us hit our time. So we'll let everybody go. Our contact details are there. You'll have them again with the follow-up email, and you'll get the slides as well. If you have any questions around anything that we've discussed today, something you didn't want to ask in this forum or that only occurs to you later, or indeed if we can be of any assistance with any competition law or merger questions, then don't hesitate to get in touch. Otherwise, hope to see you again at a future webinar. Thank you.
Thank you.